Good afternoon. My name is Lonnie Brown, and I'm the Associate Dean for Academic Affairs here at the Law School, and it's my honor and privilege to welcome you to our 111th Sibley Lecture. This preeminent lecture series honors the memory of John A. Sibley, a 1911 graduate of the law school. During his long life, Mr. Sibley distinguished himself as a lawyer, banker, and unparalleled supporter of the university. After attaining great prominence as an attorney with the highly respected Atlanta law firm of King & Spalding, he became general counsel to Coca-Cola Company, and later the chairman of the board and president of Trust Company of Georgia, now known as SunTrust. Throughout his enviable career, Mr. Sibley was always a devoted and influential alumnus of the university, serving as the president of the UGA Alumni Association and playing a major role in the capital campaign that led to the construction of this very building. In addition, he was integral to the law school's effort to obtain full accreditation in the 1930s. Mr. Sibley is also known for having chaired, during the early 1960s, the General Assembly Committee on Schools, which was tasked with the difficult assignment of ascertaining public sentiment regarding a federal court order that mandated desegregation of Georgia public schools. The so-called Sibley Commission is credited with laying the foundation for ultimately ending massive resistance to desegregation within the state and helping then-Governor Ernest Vandiver avoid a showdown with the federal government. Mr. Sibley remained an active business and civic leader for many more years and passed away in 1986 at the age of 98. The lecture series in his honor has a history that is as rich and impressive as his life. It began in 1964 and over the years has attracted such academic luminaries as Charles Allen Wright, John Hart Ely, Grant Gilmore, and Stanley Fish, as well as 4 U.S. Supreme Court justices: Chief Justice Earl Warren, Justice Harry Blackmun, Justice Ruth Bader Ginsburg, and Justice Antonin Scalia. The 2 annual Sibley Lectures are underwritten by the Atlanta-based Loridans Foundation, currently headed by Robert Edge, a senior partner at the law firm of Alston & Bird. We are incredibly grateful for the Foundation's continued generosity and support, without which this wonderful event would not be possible. It is now my distinct pleasure to introduce to you my colleague, Professor Beth Birch, who will introduce our Sibley Lecturer. The law school was very fortunate to be able to entice Professor Birch to join our faculty in 2011, after having distinguished herself as a gifted classroom teacher and highly regarded scholar at both Cumberland Law School and Florida State University College of Law. As a teacher, Professor Birch has been widely decorated, receiving Florida State's University Teaching Award, as well as the Professor of the Year Award. She achieved similar teaching excellence while at Cumberland and has continued that tradition here at Georgia. Most recently, she was selected by the 3rd-year class as a recipient of the John C. O'Byrne Memorial Award for furthering faculty-student relations. Her scholarship, primarily in the areas of class actions and mass torts, has been published in such respected journals as the Vanderbilt Law Review, the Boston University Law Review, and the George Washington Law Review. She is also co-author of the forthcoming 2nd edition of the Law of Class Actions and Other Aggregate Litigation. Before entering the academy, Professor Birch worked as an associate at Holland & Knight in Atlanta, where she practiced in the area of complex litigation, including securities class actions. She currently serves as the Mass Torts Subcommittee Chair for the American Bar Association's Class Action and Derivative Suits Committee and is co-editor of the Mass Tort Litigation blog. Professor Birch earned her bachelor's degree cum laude from Vanderbilt University and her JD cum laude from Florida State, where she served as the writing and research editor of the Florida State Law Review. Professor Beth Birch.
Thank you, Dean Brown. I wasn't expecting to be introduced, but it really is a pleasure to have all of you here today. It's such a beautiful Friday afternoon. I thank you all for being with us this afternoon. And it's a true pleasure to be able to introduce Professor John Goldberg, who is, at least to my mind, one of the most, if not the most important tort scholar who is living today. I could easily spend probably the rest of our hour talking about all of his accomplishments, but I assume you would prefer to hear him rather than me, so I'll give you a very quick highlights reel. Professor Goldberg earned his Master of Philosophy and Politics from Oxford University, a Master of Arts in Politics from Princeton University. He clearly didn't have enough schooling, so then he went to NYU for law school, where he was the editor-in-chief of NYU Law Review. From there, he clerked for Judge Jack Weinstein in the Eastern District of New York, and then went on to clerk for Justice Byron White in the United States Supreme Court. He started his teaching career at Vanderbilt University after practicing in Boston, and joined the Harvard faculty in 2008, where he teaches all manner of different types of tort classes and is the Eli Goldston Professor of Law. He has written more books and articles than I could count. I actually did start counting, and I lost count once I got to 50. So in all of his free time, he also serves as the editor-in-chief for the Journal of Tort Law. So without further ado, I hope you'll join me in welcoming Professor John Goldberg.
Thank you very much, and thank you for coming on a beautiful Friday afternoon when, if it were me, I would be somewhere else. I owe special thanks to Dean Brown for inviting me to give this distinguished lecture, and to Professor Birch for the very excessive introduction, and to all of you. I'm really thrilled to be here, and when I saw the list of previous Sibley lecturers, it made me a bit frightened. It's an amazing lecture series, and I congratulate the university on having this incredible stream of just amazing speakers, and I will try to live up to expectations. I'm going to talk, I hope, for about 35 minutes, and we'll happily take questions at the end, but if I'm being unclear, which I often am, you should feel free, if you have questions for clarification, feel free to raise your hand. All right, so inexcusable wrongs. Let me explain the genesis of this project, and that may help make some sense of what I'm worried about and what I'm trying to figure out. For years and years, I've taught torts, first-year torts, upper-level torts, and one year, my current dean, Dean Minow, said, "How'd you like to teach criminal law?" And I said, okay, why not? It's the same stuff, bad people doing bad things, right? So I figured I could do it, and I was wrong. It turns out it's really hard to do criminal law. But there was a point at criminal law where we got to affirmative defenses, and I'm familiar with affirmative defenses from torts, you know, battery and consent or self-defense or whatever. Then there was this section on excuses in the case book. And these were things like duress. If you commit a crime under duress, you might have an excuse. Or in sentencing, you can present excuses to the judge and say, hey, you know, be nice to me, don't be quite as harsh on me, I have a pretty good excuse. Being the deep thinker that I am, I said, I don't remember seeing this in torts. I just don't remember seeing the word excuse ever show up in torts. And if you go to the restatement or to treatises, there just isn't a category for excuses in tort. And so this got me thinking, and this is the puzzle I've been wrestling with, which is if we suppose, and that's a big if, which I'll talk about, if we suppose that tort and criminal law are to some degree worried about the same thing, namely wrongful behavior, behavior that we don't want people to engage in, if we think that excuses kind of fit pretty naturally when we're talking about holding people responsible for wrongful behavior, why do excuses show up in criminal law, and for that matter in everyday morality, but not in tort law, right? So that's what got me going, and that is the puzzle we're facing here, right? I mean, just think about your everyday life, never mind criminal law. I'm sure you're nobler people than I, but it is not unknown for me to make excuses, particularly to family members when I mess something up at home, right? Sorry, I meant to do that, I just was too stressed out, or things overtook me, or whatever. That's making an excuse. Perfectly natural reaction to an allegation of wrongdoing, perfectly plausible, sometimes at least, to say, you shouldn't be as hard on me as you were going to be because I have a pretty good excuse, right? So wrongs, responsibility, and excuses seem to go together. Tort law, as I suggested, seems to be on its face, at least, about wrongs and responsibility, right? Torts, we think of tort, the word torts means wrong, right? The word tort means wrong, right? So you'd think that tort law on its face seems to be about wrongs and responsibility, and yet we don't talk about excuses in tort law, so I'm just puzzled. How can that be? What does that tell us? So, in order to think through this puzzle, we have to do, I think we have to look at 3 different steps, or go through 3 different steps. First, we got to be clear on what is an excuse, after all, because if we're going to figure out whether excuses matter, we need to know what an excuse is, and I'll talk about that at the beginning. Then I've got to convince you that I'm right in my doctrinal claim that tort law actually doesn't recognize excuses, otherwise there's no puzzle to solve. And then I've got to convince you that tort law really is about wrongs and responsibility, right? So if either 2 or 3 is false, then we don't have a puzzle and we can all just go home and have a beer and not worry about this anymore. Okay, so first step, what is an excuse? Well, it turns out this is harder than I thought. There's a whole huge literature on this, particularly in the criminal law and criminal theory, as to what an excuse is, and a lot of it is in figuring out what's the difference between excuse and some related concepts that I'll talk about in a moment. I love this cartoon because it's a double excuse. Not only is the student making an excuse for not handing in her homework, but the dog has an excuse for eating the homework, which I think is doubly delicious. All right, so if we're going to know what an excuse is, we have to distinguish it from 2 related concepts that are very closely related but in the end different. One is a denial and one is a justification, and let me give you a simple example to explain the difference. So every time somebody makes an excuse, it is in response to an allegation of having done a particular wrong. You were supposed to pick up dinner, oh, I have an excuse. You shot that person, oh, I have an excuse, right? It's always in response to some alleged wrong. So I'm going to start with a very simple alleged wrong, which in criminal law might be identified as under the word assault, and in tort law might be identified under the law of battery. And basically what we're talking about is an intentional physical attack, okay? Now we're going to imagine somebody responding to allegations of an intentional physical attack, and we can start with a denial. I shot him. It's true I was holding the gun, and it's true the gun went off, but it was all an accident. I was holding the gun and somebody bumped into me, and that made me pull the trigger, and that made me shoot him. I never meant to shoot him. Now, we may not believe somebody who says that, whatever, but let's suppose we do. Let's suppose that's a sincere claim and the facts support it. That claim or that assertion in this context is a denial. Why is it a denial? Because the alleged wrong is an intentional wrong, right? The alleged wrong is you intentionally shot him. That's what assault is. That's what battery is. And if you respond by saying, well, I didn't actually intend to shoot him, you haven't committed that wrong. Now, you may have committed another wrong. Maybe it's negligence, but then that's a different wrong, and there might be different responses. So again, we're starting with an allegation of a particular kind of wrongdoing, and then focusing on how someone might respond to that allegation. Okay? So denial is just, I didn't do the wrong that you are alleging I did. Fine. Justification. Well, actually, I did intentionally shoot him, and I guess you could say my conduct meets the definition of the wrong, right? I intentionally shot him, that's assault, right? And that's battery. But you got to understand, right? I've got Ian here as the assaulter and Victor as the victim. You got to understand, says Ian, Victor was coming at me with a knife, screaming, I'm going to kill you. And under those circumstances, I was entitled to use deadly force as a response, at least as far as the law is concerned, because there's in both tort and criminal law, the defense of self-defense, right? And what that is a justification. And what we mean by justification is roughly, what you did meets the definition of a wrong, but at the end of the day, it's not wrong. All things considered, it was an acceptable thing to do because of some special circumstance which gave you an overriding reason to do what you did that defeats the initial allegation of wrongdoing. So when conduct is justified, we are saying it is not wrong after all, even though it sure looks like it's wrong, because you had a particularly good reason to do what you did, all right? So denial, I didn't do it. Justification, yeah, I did it, but I had a special reason that makes it okay for me to have done it. So what's left for excuses to do? All right. Well, let's think about the criminal law. One recognized excuse in criminal law is duress. Right? And duress means roughly something like the following. We imagine Ian saying, yes, I shot Victor intentionally. Can't deny it. But you got to understand, this incredibly strange thing happened to me. Right before I shot Victor, someone came up to me and said, I've kidnapped your child, and I will not release your child unharmed unless you shoot Victor. Right? And it was they showed me a picture of my child. It was a totally credible threat. I didn't know what to do. I was in a panic. I didn't want my child to suffer, so I shot Victor. I shot Victor only under duress, under this threat from this third party. Okay? Now, the criminal law, we can fight about whether the criminal law is right about this, but the criminal law, as a matter of black letter law, says that's not a justification. And we can get our heads around that, I think, by saying, put ourselves in the perspective of the victim. The victim's totally innocent. Victor has done nothing. Victor says, why did you shoot me, Ian? I wasn't doing anything. And Ian says, well, you know, I was under duress, fine, but is it really okay to shoot an innocent person? Right? The law, at least, says no, that's wrong. It's wrong to shoot an innocent person, even under duress. However, it's completely understandable that you've committed this wrong. Right? Sometimes we can't expect people to do the right thing. That's what the defense of duress basically says. You did the wrong thing. You shot an innocent person. Nobody thinks that's the right thing to do. But you have such a convincing story about why you did the wrong thing that we're going to be lenient on you. We're either going to say, never mind, not guilty, or we're going to, at a minimum, reduce your sentence or your punishment for what you did, because we just don't expect people always to do the right thing. There are some times when it's just too hard to do the right thing. Doesn't make it right, but it makes it understandable. That's what an excuse is. Okay? So we can have a rough definition. To excuse a wrong is to identify circumstances like duress that make it incredibly difficult to do the right thing. Right? Such that the wrongdoer can say, yes, fine, I did the wrong thing, but I deserve leniency. Maybe I deserve to get off the hook entirely because anyone else in my position would have done the wrong thing too. All right. What do excuses, what are they? What are they about? What do they accomplish? Well, it turns out we have norms, social norms, legal rules, about how we are expected to handle difficult situations. Right? These are not duties exactly. You don't have a duty here, but what we say is there are rules about what you're expected to endure and what you are not expected to endure. You are not expected to endure the threat to your child in the duress situation and just sit there and do nothing wrong. In other situations, take, I don't know, maybe you're in bad traffic outside of Atlanta. I know that never happens. And you're getting really frustrated, and it's understandable because it's bumper to bumper, and you're desperate to get to a party at a friend's house. And so you get so frustrated, you plow into the person in front of you. Well, at one level, that is understandable, meaning the traffic jams get people mad. We get that. On the other hand, you're expected to endure it, right? You don't get the benefit of an excuse because road rage is not an excuse, nor should it be, because there are norms of how you're supposed to handle certain pressures. And so the idea is when you have an excuse, you've observed the norm of how to handle the difficult situation, and you're entitled to some credit, so to speak, for handling that norm, right? There's the famous British World War II poster about norm. This is all about norms, right? Yes, we're getting bombed, just remain calm and go about your business, right? And so in duress we ask, you know, would the threat, this is criminal law, would the threat have induced a person of ordinary resilience to commit the wrong? That's the test for whether or not duress will be available. There's a separate question of what an excuse gets you, legally or morally. And the answer is it depends. Usually, excuses will get you some relief or leniency, but not complete exoneration. But sometimes, excuses can exonerate completely, and that, again, is our friend duress. if you successfully plead and prove a duress defense in criminal law, you're off the hook. You walk away. You're not guilty. Now that's a puzzle, which we can talk about also. How can it be simultaneously that you are deemed to have committed a wrong? Remember, a duress is not a justification. It doesn't make what you did right. You still did wrong, but no punishment. Not guilty. Is that even coherent? Some people think it's incoherent to simultaneously say, you did wrong, not guilty. I don't think it is, but we can talk about that. Okay. All right, so now I've given you at least, I hope, an outline of what an excuse is and how it's different from a justification and a denial. Now, step 2 of the analysis. This is the part where I have to convince you that tort law doesn't recognize these things called excuses, right? Because if I'm wrong about this, again, the puzzle disappears. Well, here's the good news for me in this handy-dandy chart. If you look for the defense of duress, the defense of provocation, the defense of necessity, all of those show up as named or nominate excuses in criminal law. None of them show up as named or nominate excuses in tort law. And in fact, there are tort cases, not many, I concede, but there are tort cases where courts have actually held, doesn't matter that you were under duress, no excuse for battery, pay up. You pay damages for a battery committed under duress. So there's very compelling evidence that at least on the nominate excuses like duress and provocation, tort law just doesn't care about them. You can go ahead and argue till you're blue in the face as a tort defendant that you were under duress won't help you a bit if the judge is following formal doctrine. The last category on this chart, miscellaneous, is very important. Miscellaneous is here I'm referring to anything that a criminal defendant might be able to invoke at sentencing or at punishment phase as a ground for leniency that has the flavor of an excuse. And it turns out, again, I defer to the criminal law experts in the room. I've taught it twice. I am not an expert. I'm trying. But I gather in sentencing proceedings, to the extent, when we're not dealing with mandatory minimums or whatever, to the extent the judge has any discretion in sentencing, it's totally available to the criminal defendant, at least to argue, may not win, but at least to argue any manner of excuse that the defendant can think of for which there is a factual basis, right? So you have to understand, Your Honor, when I committed the theft, I was, completely addicted to drugs. And that's an excuse. Or I was in an impossible economic situation, or I was the victim of domestic abuse, or da-da-da. All of these are excuses that, in principle at least, can be invoked at sentencing, and if the judge credits them, the judge will reduce the punishment, reduce the fine within whatever range the judge is allowed to act, okay? So, and at the level of criminal law practice, sentencing excuses are way more important. Look, there aren't that many cases of duress out there. It's not every day that somebody walks up to someone else and says, I've kidnapped your child, go hurt someone, right? So in practice, the sentencing excuses are in some ways the most important excuses. Again, I want to say, and this is the lower right-hand box of the chart, nothing like that in tort. Go to the damages phase of a tort case. You don't talk about what the defendant's excuses are. You ask, what happened to the plaintiff? How much did the plaintiff suffer injury? How much economic loss? How much pain and suffering? Et cetera, et cetera. There's no inquiry. It's just not part of the test, or if you will, the instruction to the jury on damages is award the plaintiff fair and reasonable compensation in light of what has happened to the plaintiff. There's no discussion, at least in principle, of what the defendant's story is about why he committed the tort or why she committed the tort. So, in all these ways, tort does not recognize excuses. Let me give you a couple more illustrations to try and convince you, focusing first on necessity. Famous case, those of you who've been in torts, Vincent versus Lake Erie, ring any bells? Boat, dock, yeah, that whole thing, right? So we got the defendant's boat at the plaintiff's dock, unexpected storm, defendant stays at the dock instead of leaving in order to save the ship, even though the defendant is supposed to leave. The defendant ends up damaging the dock because the ship, while staying at the dock, is banged against the dock by the storm, etc. Jury says $500 damages for trespass. Trespass to land. You were on the dock when you had no permission to be on the dock. That's a trespass. The trespass cost $500 worth of damage, pay up. Defendant's appeal invokes the concept of necessity. It says, look, I didn't want to stay at the dock. Yes, I chose to stay there, but it wasn't my first preference. My first preference would have been to leave, but there was this terrible storm. I couldn't leave. If I left the dock, in all probability, the ship would sink. I would have had to just cut the boat loose, because there's no way sailors should be going out in that storm. I would have cut the boat loose. The boat would have sank. And so I decided to stay at the dock. That was the right thing to do. And the Minnesota Supreme Court says, interestingly, yes, that was the right thing to do. Pay up. All right? Well done, boat captain. You did exactly the right thing by saving your ship. Pay up. How can that be, right? And the answer is necessity doesn't count either as a justification for a trespass. It does not make the trespass right, nor does it count as an excuse, an argument for leniency in the liability one faces for the trespass. Once you deliberately remain in a place that you are not allowed to remain because it's someone else's property and they have not given you consent to stay there, you have trespassed. That's the definition of a trespass, to intentionally put yourself in a place that's someone else's, that someone else owns, and that you have no permission to be at. That's a trespass. The fact that you trespass for a good reason is of no interest, says the court, basically. They don't use those words, that's my paraphrase, but that's the idea. It does not excuse or even justify a trespass that you have a darn good reason for trespassing. Okay, so that's an example, a famous example, I think, of a case where if we would see an excuse, it would surely show up here, and it's not showing up. Another example, negligence. Okay? Our old friend fault, the reasonable person standard, you all remember that from first year law school, right? If you haven't got this yet, tort students, you might want to write it down, right? We all know the objective reasonable person standard. Notice that the circumstances that matter do not include things like the stress under which the defendant acted or the relative experience of the defendant. So you might, as a new driver, let's say, and I give this example with a certain amount of anxiety as I have a new driver in the household, but you might have a new driver who's driving in a storm and drives badly in the storm, swerves when he shouldn't have, let's say, and says, well, look, I've never been in a storm before. Driving in a storm, that's pretty intense when the water's coming down in sheets and you can't really see, and it's scary and it's unnerving, and that's why I suddenly changed lanes, and that's why I hit the guy next to me. At least as a matter of black letter law, negligence law says tough. Doesn't matter that your inexperience gives us a pretty good account of why you were careless. What we want to know is, did you drive under the circumstances the way a prudent person would drive? You didn't. You swerved when a prudent person wouldn't have swerved. Pay up. Okay? So again, now for the more perhaps seasoned members of our audience may recognize this. It's a still from an old movie that's on every Christmas or holiday season rather, called It's a Wonderful Life. A Jimmy Stewart movie, lovely sappy Jimmy Stewart movie. This is a character named Mr. Gower. Mr. Gower is the friendly pharmacist in town, and I won't bore you with the details, but the bottom line is, in one scene in the movie, he's distraught over the learning of the death of his son, and he misfills a prescription, and he sends it out into the world. Fortunately, our friend Jimmy Stewart is there to prevent the prescription from poisoning the person to whom it is being sent. But then later in the movie, we are told to imagine the world without Jimmy Stewart, to see the value of Jimmy Stewart's life. And in that world, Mr. Gower sends out the misfilled prescription. Jimmy Stewart is not there to intercept it, and it is sent to the kid, and the patient is poisoned, and we learn that Mr. Gower has become the pariah of the community. He's an outcast. He is actually, according to the movie, put in prison for 20 years, which seems rather harsh for an accidental poisoning, but hey, you know, different times. Why do I mention this? Well, this is not actually a legal case and does not stand for any legal doctrine, but nonetheless, I think illustrates nicely the idea of the question we're asking in negligence is, did you make a mistake or didn't you? And if you did make a mistake, it's on you. And when Gower says, I was distraught I just learned that my son had died. I was beside myself. The law, and in the movie, the community says, tough. Right? You made a terrible mistake. You did not live up to what the standard we expect pharmacists to live up to. That's all we need to know. And you injured someone. That's all we need to know. Negligence does not recognize excuses. Okay? There are these special cases, I concede, of so-called sudden emergencies. This is when you're driving along, perfect weather, no problems, and out of nowhere the asteroid arrives in front of your car and causes you to swerve, and you hit someone. What do we say about those cases? I would say you are not excusing imprudent conduct. Instead, swerving is prudent, or at least not imprudent under those circumstances. That is, there's nothing to excuse in the sudden emergency cases. Now, here I'm taking on George Fletcher, who famously argued in a 1972 article that the sudden emergency cases are the key to understanding all of tort law, because they're about excuses, and therefore tort law is about excuses. Whatever one thinks about the sudden emergency cases, Fletcher's inference from an obscure corner of negligence law to the general contours of tort law is, I think, indefensible, but I won't say anything more since he's not here to defend himself. All right, so let's suppose I've convinced you, and I realize I may not have, but give me a benefit of the doubt here. Let's suppose I've convinced you about what an excuse is as compared to a justification and a denial. And let's suppose I've convinced you, or at least maybe convinced you, that tort law doesn't recognize excuses. I'm almost there, but we've got one more step to go, which is, remember I said this is only a puzzle if we think that tort law is all about wrongs and responsibility. Because in worlds where we're not thinking about wrongs and responsibility, we may not care about excuses. So the absence of excuses in tort law would be uninteresting, potentially, if tort law is not about wrongs and responsibility, as I earlier asserted it was. Now, there are other people, very smart, very accomplished people, who would say this is the step where everything goes haywire. They will say, you know, interesting presentation maybe to this point, but we're now going to go off the rails because it turns out tort law is not about wrongs and responsibility. And in fact, you've disproved your own puzzle, Goldberg, because by pointing out in step 2 that tort law doesn't recognize excuses, you've gone a long way towards proving that tort law is not about wrongs and responsibility. Because if it were about wrongs and responsibility, we sure expect it to be talking about excuses. So in fact, the absence of excuses has been seized upon by other scholars to establish that tort law is not about wrongs and responsibility, in which case the puzzle disappears. Who are these people? Well, there's our friend Judge Posner, right? Says, look, you've done an excellent job arguing for the law and economics view of tort law, Posner would say, were he here. He wouldn't give me the credit for doing an excellent job, but he would say, it turns out unintentionally you've proven the law and economics point of view. Why is that? Well, because the absence of excuses shows us that even though tort law has a moralistic veneer and uses some moralistic language, what it's really about is efficient deterrence, incentivizing people to take cost-efficient precautions. And that kind of enterprise might well have no use for excuses, because we're not worrying anymore about who did bad and who did good. That's old stuff. We're worried about who should pay such that precautions will be taken appropriately in the future. It's no surprise that there are no excuses in tort law, because tort law isn't about wrongs and responsibility, it's about deterrence. Right? He actually says this in a famous article. We could also, we don't have to be Posner to disagree with my premise that tort law is about wrongs and responsibility. We could be a certain kind of fairness theorist. So there are people who say something like the following. Look, tort law always starts with a loss, right? What is tort law about? It's about money. It's about money changing hands. We start off with somebody who's worse off because they got a broken leg or some damaged property. And now the question is, who's going to bear that loss? Is it going to be the victim? Will the loss lie with the victim, or will it get transferred to somebody else? Right? And when we ask that question, we might well decide the answer about whether or when somebody else other than the victim should bear the loss turns not on responsibility, but on fairness. Just who in fairness ought to bear the loss? If we think about tort law that way, again, the absence of excuses may not be particularly puzzling. Think about it this way. As between an excused wrongdoer, yes, I was negligent, but I have a pretty good story about why I was negligent, and an innocent victim, I'm hurt through no fault of my own, who in fairness should bear the loss? There's a respectable argument that in fairness, the wrongdoer should bear the loss, even the wrongdoer who has a good excuse. So if tort law is about efficient deterrence, or if tort law is about fairness or fair distribution of losses, then the puzzle goes away. And I think both advocates of both theories would say the absence of excuses is a reason to think the puzzle should go away. Now, the last part of my talk, I want to push back on, if you will, their intuition, the intuition I'm attributing to them, the intuition that if you're looking at a body of law that holds people liable without regard to plausible excuses, you can't be looking at a body of law that's about wrongs and responsibility anymore. It's about something else. And I want to push back on that in the last part of the talk. Okay? I think these folks are making a mistake. They're thinking incorrectly or wrongly about wrongs, and that once we think better about wrongs, we will be able to see that A, tort law really is about wrongs and responsibility, and B, it's not so mysterious that tort law's wrongs are wrongs that have no excuses. Okay? So here's a fallacy that I attribute to Posner and the fairness theorists, and I'm going to call it the moralistic fallacy. You can't really see that very well. That's the Garden of Eden. Things are about to go very badly for Adam and Eve. Goes something like this. Look, the wrongdoing, what is wrong? What does it mean to do wrong? Well, it's about doing blameworthy, culpable things, things for which someone bears culpability. It's sin, ultimately, whether you're religious or not. Sin captures the notion of wrongdoing. Excuses, where they are present, tend to undermine culpability. We think of someone who has a good excuse as being less culpable and maybe not culpable at all, like our shooter under duress. Tort law imposes liability even when the defendant has a compelling excuse. Thus, tort liability cannot be about wrongdoing. If wrongdoing is about culpability, and excuses defeat culpability, and tort law holds you liable even when you have an excuse, then it can't be about wrongdoing. Right? That's the syllogism, so to speak, that makes up the moralistic fallacy. Another fallacy, which is sometimes attributed to Kant. I am not a Kant scholar, so I have no idea if this is a fair attribution to Kant, but what the heck. This is the ought implies can fallacy, and it goes something like this. If you're going to accuse someone of being a wrongdoer, you have to be focusing on something that they had the ability not to do. Right? Avoidability, something like that. Control over the situation is a sine qua non of identifying someone as having done wrong. Think of it this way. If I say to you, all of you will have done wrong if after I'm done with this talk you do not, from a standing position, jump 10 feet in the air. And you say, well, wait a second, nobody can jump 10 feet in the air. How can it be wrong not to jump 10 feet in the air? And you're basically saying ought implies can, right? I have to be able to do the thing that you want me to do before you can declare my not doing it to be wrong. That's the basic idea. But it turns out tort often imposes liability for conduct over which we have little control, and I'll talk about this more in a minute. And again, therefore, tort liability is not about wrongdoing. Okay? So these are two ways of expressing the same thought. And the thought is, tort has this veneer of being about wrongs. The word tort means wrongs. There's talk about fault and things like that in tort law, but that's misleading because the actual terms on which tort law imposes liability are not consistent with a scheme that holds people responsible for having done wrong. Okay? That is to say, tort law holds too many people under too many circumstances liable to credibly claim to be a law of wrongs. Okay. My response is no, both of these arguments are an overreaction. They're fallacious because they're overreactions, and what I mean by that is the following. What the correct inference to draw from the, if you will, demandingness or strictness of tort liability, at least on some occasions, is not that tort law is not about wrongs, it's rather that tort wrongs are a special kind of wrong. The moralistic fallacy and the ought implies can fallacy are both fallacies because they have an unduly narrow definition of what can count as a wrong. The concept of wrong is broader than they realize without being vacuous or empty, for reasons I will try now to explain. You may ask, why is there a pretzel, a picture of a pretzel on the screen? It's a fair question. Etymology of the word tort, ultimately from a Latin verb that meant to twist. Why would the etymology of tort trace us back to the concept of a twisting or twist? Well, it seems, actually, I tell my students, once you've understood this, you've understood the whole subject. We don't have to meet again because we've got this worked out. Right? Twist. Why twist? Well, first of all, every tort is a twisting. It's an injuring. It's a twisting, making not straight, breaking something or someone else. Every tort is also twisted in the sense of not right, not straight. Someone is acting wrongfully. So it's a wrongful action that twists or injures somebody else, and the whole point of tort law is to allow the twisted victim to untwist, to make things straight, to make things right, as between the victim and the wrongdoer. Okay? So actually, tort law's etymology turns out to be quite illuminating. It tells us that, first of all, torts are wrongs, conduct that is twisted, that is not right, that is not straight. Every tort is the violation of a legal directive that defines unacceptable conduct. Do not defame other people. Do not intentionally strike other people. Do not carelessly injure other people. All the torts are of that form. They identify conduct that is unacceptable and in that sense define wrongs. Okay? Every one of tort's wrongs is an injurious wrong. There is no such thing as a victimless tort. There are victimless crimes, no victimless torts, right? Every tort starts not with a loss, but with a victim. Until you have a victim, you don't have a tort, right? That is, so we need wrongdoing and injury before we have a tort. Furthermore, every tort is what I call a relational wrong, by which I mean the conduct in question is not just wrongful in some generic sense of antisocial, it's wrongful in a more specific sense, wrong as to the victim. And there's this case called Palsgraf. Some of you may have read it, about a parcel and a train station and a lady getting knocked over and bonked on the head. If you read the opinion carefully, I would submit what Cardozo says is the reason Mrs. Palsgraf loses is because the conductors, while careless as to some people, were in no way careless as to Mrs. Palsgraf, because no one could expect that pushing someone over here carrying a nondescript package would have any implications for someone standing 30 feet away. It is not careless as to her. Okay? Finally, and not surprisingly, tort law, having defined wrongs in this very particular way as relational injurious wrongs, gives victims a response, an opportunity to obtain redress from the wrongdoer. It empowers victims. It's no accident that torts, the wrongs, line up with torts, the bestower of private rights of action. For someone like Posner, it's a bit of a mystery. Why do we connect wrongdoing in this particular sense to lawsuits? That's a completely contingent empirical question in Posner's analysis. Well, because it might get us efficient deterrence, well, let's figure that out. We'll have to do the studies to see whether it does get us efficient deterrence. On this account, it's a more of a normative connection or conceptual connection. What else would we do if we're going to be in the business of defining this special kind of wrong that is a victimization? Of course we're going to give victims the opportunity to respond. That's the whole point. That's what this is all about. All right, so why does this connect up, or how does this connect up to excuses? Basically, once you understand that torts are this special kind of wrong that are all about holding those who wrongfully injure others responsible to those they have injured, the sense of ought implies can relaxes a bit, I think. What do I mean by that? As compared at least to criminal punishment, well, again, look at it from the perspective of the victim. Go back to the duress example. You shot me. I didn't do anything. I was standing here minding my own business and you shot me intentionally. You owe me something. I'm entitled to something from you for that. Then the shooter says, but, I was under duress, da 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 da. Yeah, I get it. You were under duress. You shot me. You owe me something. The idea is when the law is in the business of defining this kind of wrong for this kind of purpose, excuses are understandably left out of the story. It's very different in criminal law when the state is in the business of punishing people on behalf of society and on behalf of social peace and stability and safety. When the state punishes, you get all kinds of protections. Burden of proof, right to counsel, blah, 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 blah. You also get excuses. That's why there are excuses in criminal law, because the state owes you excuses in criminal law if it's going to be in the business of punishing you. This isn't that. This is a different realm of wrongdoing. This is about answerability of wrongful injurers to their victims, not answerability of wrongdoers to the state. It's a different form of wrongdoing. It's a different form of accountability, and excuses are less significant and appropriately less significant for this kind of wrongdoing and this kind of accountability. My anime prosecutor is meant to convey the power, awesome power of the state coming down hard on the criminal defendant. All right. Relatedly, there's, if you will, a kind of procedural component to the point I'm making, which is, what does it mean for tort law in reality? What does it mean practically for tort law not to recognize excuses? Well, again, go back to criminal law. In criminal law, if you invoke one of the recognized excuses like duress, you're making an argument to a judge and maybe a jury. Excuse me, you say to the judge and jury, recognize my excuse and get me off the hook, or at least reduce my punishment. By not recognizing excuses, what tort law is effectively saying to the wrongdoer is, tell it to the victim. Don't talk to the judge and the jury about what excuse you have. They don't want to hear it. It's not part of their decision making. If you really think you've got a good excuse, you can convey it to the victim. That's part of how tort law empowers victims, by giving victims, rather than judge and jury, the say over whether to recognize an excuse and to what extent. Now, how would a victim give recognition of an excuse? Well, there's lots of ways, and guess what? This actually happens in the real world. Most tort victims don't sue. And in certain areas like medical malpractice, the evidence we have, which is admittedly sketchy, 9 out of 10 malpractice victims don't sue. They've got good claims, they don't sue. So every time you hear about the tort system being out of control, that's a good fact to keep in mind, assuming it is a fact. Why do 9 out of 10 victims not sue? I would suspect a lot of them because the doctor says, I screwed up, I'm sorry. You've got, if you've got insurance, I hope that'll pay for your bills. If not, maybe I can help you out, blah, blah, blah. And the victim says, fine. The victim excuses the wrongdoer, even though a wrong has been done, at least in some of those cases. So, and that's the victim's choice. Victim doesn't have to, but that's the whole point. It's in the hands of the victim, not the judge and the jury. Okay, last slide. Let me just make clear what I am saying and what I am not saying. I am not saying that tort law ignores excuses because it's a compensation system, because it's about getting money to victims. I don't think of the money that goes to tort victims as a compensation system, like a social safety net kind of system. You get money in tort not because you need it, the way you get disaster relief because you need it. You get money in tort because you've been wronged. So this is a claim not that tort is a compensation system, it's a claim that tort is a particular kind of wrong that generates a particular kind of remedy and it's a system in which excuses don't figure and probably shouldn't figure. Okay. Comparison. Some of you may already be thinking, wait a second, if tort law doesn't recognize excuses, that's kind of odd because we took contracts. And in contracts, there were some cases where you could excuse breach of contract, like impossibility. I was all set to perform, then there was the earthquake that came out of nowhere and I couldn't get my widgets to you on the appointed day. My breach is excused, performance was impossible. If contract law, which has a lot of the same features of tort law, including holding individuals responsible to other individuals, et cetera, and if contract law recognizes excuses, doesn't that make tort look weird? Why would tort law not recognize excuses if contract does? Well, my answer is to say contract law doesn't recognize excuses. That impossibility actually is not an excuse for breach of contract. It's a non-breach of contract. That is to say, it's a denial. Why? How can it be a denial? Well, because it turns out the courts say pretty much every agreement that's entered into has an implicit condition which says, I agree to deliver widgets on such and such a day unless it's impossible. That's part of the promise. That's how courts read the promise. And so when they don't enforce the promise because it's impossible, they're just saying no breach. It was a condition built into the contract. And I'm not just making this up. This is not just wordplay. If you read the opinions, that's actually what the courts say. And one piece of evidence of this is you can contract around this. It's a default. So if you want to waive the impossibility condition in your contract, you can. You can say, come hell or high water. There are these clauses, hell or high water clauses. Come hell or high water, I will deliver. Right? Okay, finally, suggestion, and then I'm done. Thank you for your patience. My larger interest, if you will, the larger idea I want to try and convey today is that we need to be broader and more open when we think about what wrongs are. We tend to think about wrongs in sort of fire and brimstone sense, blameworthy, culpable, etc., but that's not what the essence of wrongdoing is. That's a kind of wrongdoing, but it's not the essence of wrongdoing. The essence of wrongdoing is not living up to a standard of conduct or a standard of right conduct. And some standards of right conduct are pretty darn demanding. We may have very little control over our ability to meet them, at least over the long term. It has been famously observed by many other scholars, including Mark Grady. All of us, sooner or later, are going to commit negligence, right? May not get sued for it, but good luck trying to drive your entire life without driving carelessly. It's not going to happen. No offense to anyone in the room. I'm sure you're excellent drivers, but it's impossible to consistently live up to the standard of care every day, every moment of your life. And in that one moment when you do, or one of those moments when you fail to live up to the standard, hopefully you're lucky. Hopefully you're lucky and you don't hit anybody. And if you don't hit anybody, that's fine, that's the end of it. But if you do hit someone and they sue you, and you say, I drive carefully every other day, nobody can expect to drive carefully every time they drive. Tough luck. Negligence is demanding in that way. And that's just one example. Products liability. You send a product out into the world that has a defect and it injures someone, you pay. But I had the best quality control in the world. Tough. You sent a defective product out into the world. The standard in strict products liability is a standard which says, do not send defective, dangerous products out into the world. That's the standard. And that's cogent as a standard for what counts as wrongful conduct. It's very demanding. It's very strict. People can't comply with it all the time, but so what? It's still a wrong. And the whole point of this paper is to suggest that there are some wrongs for which excuses just don't matter because the wrong is defined in a particularly demanding way, and that's fine. That's just one way to do wrongs, and it's an appropriate way to do wrongs in a scheme that is all about holding wrongdoers responsible to the victims that they injure. So I'll stop there and take questions. Thank you. I want to change it. The question is, if the doctrine of public necessity in tort law, unlike private necessity, actually does some work in relieving tortfeasors of liability, doesn't that throw a monkey wrench into the argument that tort law doesn't recognize excuses? Is that a fair paraphrase? The short answer is public necessity, to the extent it spares defendants from liability, is typically a justification. It's typically, it was the right thing to do to burn down your house in order to save the village. Overwhelmingly, it's connected to the state being the one who acts rather than the individual is the one who acts, and that's part and parcel of it being a justification, I think, where the idea is we tend not to trust neighbors very much making judgments about your house needs to burn down to save mine. We're a little worried about sort of judgments to that effect, but if the fire department is doing it, or at least doing it under emergency circumstances, we might be a little more comfortable thinking that that was the right thing to do, all things considered. But it's a fair question. Sorry, was there a criminal law dimension to it?
I just wondered if you're focused in the criminal
Yeah.
context as the state interest versus the victim interest.
Right.
That helps inform the distinction.
Yeah, it might. I mean, again, I think for the reasons I said, I think that the public nature of public necessity and the fact that it's typically state actors who are invoking it suggests its character as a justification. Okay, great. So the question is, on my account of excuses where it's important in tort to give the power to excuse to the victim, wouldn't we expect the parallel in criminal law to be that there's a power to excuse bestowed upon the sovereign who's bringing the criminal law cases and in some sense is the victim of the crime, such that rather than a mandatorily recognized excuse in law like duress, we would see discretionary recognition of excuses, as we do say with a pardon. We do, first of all, obviously there are discretionary excuses, and in fact there's the famous criminal law case that you all read, probably the cannibalism case, Dudley and Stevens, where the shipwrecked sailors eat their shipmate, and they end up getting prosecuted for murder and convicted. And eventually the Queen commutes their sentences, and I think that was largely the recognition of on the grounds of that was an excused. Under those circumstances, even something as horrific as murder is excusable, at least partly. So clearly there is some power like that in the sovereign. I guess what I would say is that's good, but it's not good enough. The state owes you more when the state is in the business of prosecuting you and punishing you and potentially depriving you of your liberty. It's great that they do exercise that discretion when they do it appropriately, state actors, but it's part and parcel of the rights that a person enjoys against state punishment. That you not only have discretionary excuses, but that you have sort of legally recognized excuses. Now, I don't know that I'd go so far as to say it would be unconstitutional, for a government not to have excuses built into its criminal code. That seems a little strong, but certainly as a matter of kind of normative principle, the state power to punish is an awesome power in the old sense of awesome, not in the Bill and Ted's Excellent Adventure sense of awesome. That's a very dated reference. Sorry. But so I think the fact that it's the subject's rights are more vulnerable, the liberty interest is more profound, and the state is bringing the action, all of those counsel in favor of at least at a normative level, giving the wrongdoer more protections. Yeah. So the question is, if I'm inviting people to think about wrongs more broadly, and if tort law is really, as I say, all about holding people responsible for a particular kind of wrong, how would I assess the system in terms of its, is it actually doing what it ought to be, what it purports to do? And I would give our tort system probably a B-. I don't know what the grading system is here, but that's not a great grade. Now, keep in mind that it's rare for any government or legal institution to do much better than a B+. Right? There aren't a lot of A's out there to be had. But why a B-? Well, for all the reasons critics of the tort system have pointed to as reasons to get rid of the tort system, I think that's an overstatement, but it's slow, it's expensive, sometimes the wrong people end up winning. So there's some data which suggests that the people who are most deserving of recovery don't sue or don't win, and the people who are least deserving of recovery do sue and do win. I don't know how generalizable those findings are, but if they are, obviously, then something is going wrong. And more generally, there's research which says something like the following. Look, in any kind of a complicated case, or not even that complicated, in basically any malpractice claim, medical malpractice claim that isn't a slam dunk, if the claim is not expected to generate a settlement or damages of $250,000 or above, you won't be able to get a lawyer to bring your claim. It won't be worth it financially because the lawyer gets a third, 80,000 whatever, 83,000 or whatever, and that's not going to be enough to cover the expert fees, the court filings, the lawyer's time, etc. And there's something very messed up with a system that says unless your claim for medical malpractice is worth $250,000, you can't get a lawyer to represent you. So there are lots of ways in which tort law fails to meet its aspirations, and I think, to me, one of the biggest challenges that we face is how to if this is what it's about, how to make it better, do better what it's supposed to do. Yeah, yeah, okay. So great. So the question is, what role or what's the connection between my emphasis on torts being wrongs, my emphasis on these being a special kind of wrong for which there are few excuses and where the standards of conduct can be quite demanding, and my concluding suggestion that what makes torts wrongs is that there's a legal rule which says don't do X, which sounds, if I may, this is my speaking, not you, but it runs the risk of expanding the concept of wrongs only by turning wrongs into a vacuous concept whereby whatever the state prohibits is wrong, which is an uninteresting sense of wrongdoing, right? So I clearly don't want to make that last move, and I don't think I have to make that last move. So let me try and explain. When I say that I think we need a more expanded or capacious conception of wrongdoing, I have at least two ideas in mind. One is that we maybe shouldn't get our backs up as high when we hear about wrongdoing. That is, we tend to think of wrongdoing as the sort of thing for which someone should be ostracized or castigated. Think of, do you know Nancy Grace on television, right? You know, so Nancy Grace is like the poster child for if you've done something wrong, you deserve to burn in hell, right? And that's it. End of story. And that the sort of Nancy Grace instinct, if you will, seems to me very problematic and troubling, because lots of wrongs are wrongs, but don't warrant that kind of response. Now, what makes a wrong if it doesn't warrant, if it's not that it is the kind of conduct that warrants that sort of response? And there I want to say, yes, it's about what the law proscribes, but it's not just anything the law proscribes. That is, the law has to speak a certain way in order for the law to count as defining a wrong. And in particular, the law has to say, you have an obligation to conduct yourself in a certain way in light of the injury you might inflict on another person, right? So every tort is of the form, don't go around saying bad things about another person so as to harm their reputation, for example. That's defamation. It's not just a prohibition for prohibition's sake. It's identifying a species of conduct that is has the characteristics of wrongdoing in a more general sense, right? It's a bad thing to do. It's an unacceptable thing to do. This is no way to behave. You have breached a standard of right conduct, right? It's just that the standards of right conduct, the universe of standards of right conduct, is quite a bit larger than we sometimes think. So I think it's cogent to say in strict products liability that in a non-vacuous sense, a manufacturer who sends a defective product out into the world has done something wrong and injured someone, has done something wrong simply on that description. We don't have to get into the question of how careful was the manufacturer, how prudent was the manufacturer, how much money did the manufacturer spend on quality control. Just sending out a dangerous, defective product into the world that injures someone is a wrong. It's not the kind of wrong for which the pitchforks should be brought out, right? It is not the kind of wrong for which someone ought to be run out of town, ostracized, punished, ruined, etc. But it's still a wrong because there was a standard which says, here's how you need to behave in light of the possibility that your conduct might cause injury to someone else, and you didn't meet the standard. Now, contrast that with what is sometimes called absolute liability. Let's say, as is, alas, not a fictional case, I am on the tennis court and I trip over a perfectly good tennis ball and break my wrist. Very clumsy thing to do. I sue the tennis ball manufacturer and I say, but for your tennis ball, I never would have tripped, I never would have broken my wrist. If the manufacturer is going to be held liable under that circumstances, we're no longer in the world of wrongs. The manufacturer has sent a tennis ball out into the world, true, but the manufacturer has not sent out a defective tennis ball into the world, and that makes all the difference, right? We're asking the manufacturer to live up to a certain standard of acceptable behavior, and it's not acceptable, at least one could argue, to send out a dangerous product into the world or a defective and dangerous product. It is acceptable to send a non-defective product. In fact, it's encouraged. And so even though that's very strict liability in one sense, because we don't care about the manufacturer's fault, it's still tied to a notion of you didn't meet a certain kind of standard of conduct.